Good afternoon. I'm Rudy Lehrer, Chair of the Litigation Section. On behalf of our section, we are pleased to sponsor today's program, Ins and Outs of Arbitration Law. Today's speaker is Jeffrey Raskin. Mr. Raskin is an appellate attorney and partner at Greines, Martin, Stein and Richland LLP, where he handles all manner of civil appeals and writs. Mr. Raskin has twice been honored with the prestigious California Lawyer Attorney of the Year Award for precedent-setting victories before the California Supreme Court in various different areas of the law, including estates and trusts, attorney ethics, and arbitration law. Mr. Raskin has developed particular expertise handling a wide array of arbitration-related issues at the trial, appellate, and Supreme Court levels. We're honored to have him present today. Excuse me. Two quick housekeeping and calendar points for you today. On August 4th, we'll have the litigation section's next war story series featuring Gary Bostwick and his epic libel case, Mason versus New Yorker. Alexander Rufus Isaacs will be the moderator. And for those who have time, please be sure to participate in the bar's mentorship program. It's an incredibly rewarding opportunity to assist junior attorneys starting their own practice. And with that, I'm going to pass the mic to Jeff.
Good afternoon, everyone. My name is Jeffrey Raskin. And as you just learned, my firm and I handle all sorts of civil appeals. But in particular, and that ranges the full gamut from business law to property to trust and estates, employment, family law, you name it. But I in particular have a lot of experience in arbitration issues. And while I can't possibly go over everything arbitration related in an hour, my hope is to give you a framework to use, essentially how I look at things, how I issue spot as I go through whatever the particular arbitration law is, what I find useful in evaluating, what I find useful in arguing, and some pitfalls that I've noticed along the way. So how much arbitration do I do? A lot of arbitration. These are just my published Court of Appeal and Supreme Court decisions. For everyone here, there are many, many more that I deal with that are unpublished decisions of mine, cases where I work with trial lawyers to help them on their petitions to vacate or petitions to compel arbitration. So this is the kind of primer of what I have. Now, whenever I talk about arbitration law, I actually like to talk about bankruptcy law. And the reason why is I clerked for a judge on the Ninth Circuit, Judge Fisher. And he was always very, very good and very, very trusting about allowing the clerks full freedom to divvy up our cases in any way we like. And there was one exception. One time, Judge Fisher called us all in and said, please tell me that one of you has some background on bankruptcy law. And he didn't do this for anything else. Giant international law cases, complex issues of constitutional law, that's never bothered him. But bankruptcy law, he wanted someone who had some background. And it always, I always kind of wondered why. And in time, I came to understand, bankruptcy law really is this kind of entity unto itself. It is a complex system where there are lots of competing public policies that are driving all of the statutes and decisions. And if you understand that background, those mechanics, those policies, it's a lot easier to understand how bankruptcy law is going to move, how it's going to react, how it's going to deal with things. It just becomes a lot more intuitive. And arbitration law is very much the same. So to me, in my head, arbitration law looks like this. Like the matrix, arbitration is a system. It's a system of rules, substantive rules, procedural rules, all designed to lead inevitably to one outcome: push you into arbitration, keep you in arbitration, and confirm whatever the award is that the arbitrator issues. It's a prison not for your mind, it's a prison for the arguments that are available to you. Now, if you're trying to compel arbitration or trying to confirm an award, that makes you an agent of the matrix. You are guarding all the doors, you are holding all the keys, and you act like it. Your job is not to convince the judge that you're right. Your job is to remind the judge that he or she is also a part of the matrix. He or she knows what their job is to do. Compel arbitration, keep you in arbitration, confirm the award. To do this, I hammer very heavily on policy, and not just in some general overview section, background heading of your briefs. It needs to be incorporated everywhere all the time, underlying everything you write and everything you say. And in arbitration law cases, we find these come out almost like fortune cookie little nuggets of law that are repeated again and again, and judges know them, and they're comforting. And hearing them gets the judge's head nodding up and down and up and down. And now you just need to keep that head nodding up and down. In fact, we see them in cases like, there are cases like Moncharge and Greenspan versus LADT, but I also see them in cases where they're recited not because it's an applicable principle, but because this is what we say whenever we do arbitration cases, and it feels good. So what kind of things? There's a strong public policy in favor of arbitration. All doubts are resolved in favor of arbitrability. The parties have a strong expectation of arbitral finality. The court is required to indulge every reasonable intendment to give effect to the award. By the way, intendment is a 14th century word. I know of it coming up only in the arbitration context, and every now and then in a constitutional context. Why use it instead of intent? Because it makes arbitration seem that much more important, powerful. Arbitrators are not limited by dry law. They have full access to rely on broad principles of equity and justice. The parties expect minimal judicial involvement. There are many, many more of these. Now, if you're trying to avoid arbitration, or if you're trying to vacate an award, your job's tougher. It makes you one of these guys, except you can't be Neo because only I get to be Neo. But the core thing that you need to remember is it's not just how good your argument is, because your opposing counsel is not the enemy. The system is your enemy. The judge knows what he needs to do, and you need to break the judge out of it. The deck is always stacked against you. Always, the first step of the analysis is thinking, are we under the California Arbitration Act or the Federal Arbitration Act? Now, 9 times out of 10, there is no difference. But man, that 10th time can really get you. So don't be lulled into what I see so often, thinking that we're in state court, the contract doesn't say FAA, so obviously the CAA applies. That's not how it works. In fact, as the Supreme Court has very recently reminded us, the FAA does not confer subject matter jurisdiction at all. So the vast majority of FAA cases are going to be decided in state court. And in fact, in petitions to vacate an award, federal courts won't even look through at what the underlying claims are. So you had a federal question, doesn't matter. That's not enough to create federal jurisdiction. You're in state court. The standard is broad. In fact, it's as broad as the Commerce Clause of the Constitution will allow the Congress to go. If the arbitration provision is in a contract evidencing a transaction involving interstate commerce, that's it. How broad? Well, involving interstate commerce is treated as affecting interstate commerce. It doesn't matter that the parties to the contract never intended to be dealing with interstate issues. All that matters is that it turned out that interstate commerce was involved. It's a highly factual test. So you sue a termite company for breach of contract. They did a bad job at clearing out the termites. Well, the pesticide moved in interstate commerce. The FAA applies. There's a debt restructuring agreement between Alabama parties executed in Alabama. That too affects interstate commerce. Why? Because the original debt that you're restructuring was incurred in order to engage in interstate commerce. So as you see, it's a highly factual test, a very easy to accomplish test, but because it's factual, it needs to be raised in the trial court. You need to make your record. You need to establish that interstate commerce connection. In terms of things to look for, I have seen plenty of instances where lawyers will cite an FAA rule, an FAA remedy, without arguing that the FAA applies, because they're just not being careful when they look at the case to notice you're dealing with FAA. That may well lead you in a totally different path. Additionally, think about it strategically. As I said, most often there is no difference, but when it does, it can make a big difference to your client. And so deciding what rule helps you in your particular case, is it worth raising the FAA to go after that? Or should it be something that's not mentioned, at which point state law will apply? When we're talking about compelling arbitration, basically the mental steps we go through are 4. Number 1 is assent, which works exactly as you'd expect it to. It is ordinary principles of contract law, so we're not going to get into it. The other 3 are far more interesting and important. Number 1 is the claim within the scope of the arbitration agreement, and who decides that? Is there a defense to enforcement, and who decides that? And lastly, a very powerful and very often overlooked exception that will buy you a ticket out of arbitration, even if you have an enforceable arbitration agreement and a claim that is within that contract. If you are looking to avoid to compel a case to arbitration, you're going to hammer all of the strong policies in favor of arbitration, that all doubts are resolved in favor of arbitrability. And the analysis almost always begins with the language of these kind of broadly written provisions. And I divide them into broad provisions and narrower, because there's no true narrow provision unless it's really, really pegged to a very specific thing. Now, the matrix operates very strongly in this area. For instance, I'm not sure what a claim that arises from the contract is as opposed to one that arises out of the contract, but using either of those 2 phrases gives you a relatively narrow agreement, but sticking these 2 things together somehow produces a much broader agreement. The Ninth Circuit and California courts tend to disagree. California courts tend to view the narrower ones a little more broadly, might even involve tort duties that arise from the contract itself, whereas the circuit tends to lean more into seeing this as being about interpretation and performance of the contract. If you're trying to avoid arbitration, you have policies on your side as well. You're going to emphasize that no policy, no matter how strong, requires accepting arbitration of controversies that the parties never agreed to. My case that I always point to on this is one of my own published cases, Rice v. Downs, and the lesson here is to go very, very slowly and methodically, and to insist that the court does so as well. So in Rice v. Downs, we had an arbitration clause. It covered all claims arising out of this agreement. That is a narrower form, but one that still tends to lead to fairly broad results in California courts. But we never, ever read a contract provision in isolation. Whatever we're interpreting a contract, we always look at the contract as a whole. And so here we had a jurisdiction provision, but we see similar things in fee shifting provisions and a variety of other kinds of contract provisions. And here, that provision addressed when the courts of California, whether it be federal or state, have jurisdiction, are in cases arising out of, under, or in connection with. And so marrying these two, clearly the parties here had a very good understanding of how to broadly address all claims. And when you compare that to the far narrower arbitration clause, you see that they intended much, much more restraint in terms of arbitration. Defenses to enforcement are almost always the same defenses that we have to any other contract. Unconscionability, duress, mental incapacity. But we don't need to go over the substance of that because you know that. Some interesting ones are waiver. Now, sometimes we see in arbitration agreements a contractual time limit that arbitration has to be instituted within a certain amount of time. That can certainly lead to a waiver argument. But far more often, it's a matter of litigation, that they have used the litigation machinery to some substantial degree that is inconsistent with invoking your right to arbitration. Now, the US Supreme Court has just recently created a big wedge for us regarding the FAA and CAA. It has long been the rule in California and in the circuit that using litigation, even extensively, is not enough. There has to be prejudice to the other side, somehow impairing the benefits of arbitration for that other side. Typically, it's things like engaging in such substantial discovery that you wouldn't have obtained had we gone directly to arbitration, waiting until the eve of some major hearing or trial. But the FAA under Morgan versus Sundance now goes the opposite direction. The Supreme Court has made clear that the FAA exists to prohibit judicially historic aversion to arbitration, but not to make arbitration more likely. So in order to determine contract waiver of a contract right, we don't normally look to prejudice, and we won't do so here either under the FAA. Now, the more interesting question is actually one of who decides the enforcement question. And this turns largely on whether we're talking about it being a defense to the entire agreement, or a defense to one provision, or a defense specifically to the arbitration clause. But as we'll get into, the parties can delegate differently, can assign additional things to arbitration. Now, under the FAA, the way that the courts deal with it is to treat the arbitration provision as a separate, severable agreement. And so the defense, in order to be heard by the court, has to be addressed specifically to the arbitration clause. If it is a defense to the contract as a whole, we treat that as a defense to the kind of merits, the substantive part of the contract, not to the separate arbitration agreement. So something like fraud in the execution will get you a decision by a judge, but fraud and inducement to the whole contract, mistake, duress, these are things that the federal courts are going to push always to the state courts, or I'm sorry, always to the arbitrator to decide. The federal courts and state courts are largely in agreement. In fact, very often the state courts just look to the FAA and say, that seems persuasive to us. And we too will send everything to the arbitrator, treating it, the arbitration clause, as severable. There are some notable exceptions. And the big one really is whether the contract is illegal for violation of public policy. So the way this works in federal court, if the arbitration provision itself violates public policy, we will have a judge decide that. Very difficult to imagine a situation where that happens. In state court, if you're challenging a single provision that does not affect the arbitration provision, we will allow arbitrators to decide that public policy issue, no matter how significant the public policy issue is. But if it goes to the entire contract or to the arbitration provision, that we will allow the courts to deal with. And the idea is that if the entire contract is void, well, then the arbitration provision falls along with it. So another one of my cases involved this. It was Shepard Mullen versus JM, decided just a few years ago. It involved an attorney retainer agreement that violated public policy because the attorneys didn't disclose an existing conflict. This went to the heart of the relationship that was created by the contract, and so it's enough to void the entire retainer agreement, including the arbitration provision within it. And so this was for the court, not for the arbitrators to deal with. Now, interestingly, it was never argued to the Supreme Court that they should change the law on this, that they should make it so that the FAA and CAA are mirrors. And the Supreme Court specifically noted that and left that question for another day. While these are the default rules, and we've also gone over the default rules in terms of understanding the scope of arbitrability, a question that is always for the judge to decide, parties can clearly and unmistakably delegate arbitrability and enforcement and scope issues to the arbitrator. It just has to be clear. Now, you want to look at the contract itself, but you also want to look at arbitration rules. The FAA rules, the JAM rules, at this point almost always include a delegation provision. And if the contract incorporates that by reference, then the parties have clearly and unmistakably delegated arbitrability to the arbitrator. At this point, the trial judge has no power other than to look at the delegation clause itself. That too is treated like a separate contract. And the only question for the judge is the delegation clause enforceable? If so, the arbitrator decides whether we have an enforceable arbitration agreement and whether we have a claim within the scope. This can take two forms generally. The top is the much more clear, something that covers existence, scope, or validity. We see this very often in arbitration rules, but courts have also been willing to do the same for a delegation of any dispute concerning arbitrability, because courts have always defined arbitrability as involving not just the scope of the arbitration clause, but questions about existence, validity, defenses to the arbitration agreement itself. Now, the last area here is the exception. And like I say, I've seen this one missed many, many times. I've seen cases that I have won that had this been raised, it may well have come up a different way. So third parties are often the spoiler in any election, taking votes away from the others. And third parties can be the spoiler to an arbitration agreement. So if you have a claim by or against a co-plaintiff or co-defendant who is not party to the arbitration agreement, that party cannot be compelled to arbitration. And whatever the result of an arbitration between the other parties is, it won't be binding. Collateral estoppel won't apply in either directions. So we have a statute, 1281.2c, which makes clear that under these sort of circumstances, the trial court has discretion to deny arbitration to everything. So if the claim arises out of the same transaction, and there's a possibility of conflicting rulings on even one common issue of fact or law, that's enough. The trial court now has discretion, deny arbitration entirely, move on. It can't clear its docket anyway. It might as well hear the entire case. When it comes time that you have now emerged from arbitration and you have an award, the first question that you need to be asking yourself is, do you in fact have an award? That sounds a little ridiculous, but arbitrators issue all sorts of things. They issue final awards, they issue interim awards, partial final awards, rulings, they label things, all sorts of things under the sun, and they sometimes label something other than what the law treats it as. Why do we care? Because it tells us the demarcation line between the arbitrator's power and the trial court's jurisdiction. Under 1285, a party to an arbitration in which an award has been made can petition to confirm, correct, or vacate. So what's an award by statute? It's that which determines all the questions submitted that are necessary to determine the controversy. And this makes things seem very easy. A final award clearly is final and decides everything. An interim award obviously does not, so it isn't an award. And a partial final award is this bizarre, non-existent, paradoxical sort of thing. But we have surveyed 99 appellate justices, and they tell us that a partial or final award, like a final award, does determine all questions, and therefore is subject to confirmation and vacatur, meaning you can and you must seek vacatur immediately. So what's the difference between an interim award and a partial final award? An interim award typically will deal with threshold questions, a phase one issue, and there is no impediment to moving on to phase two immediately. A partial final award is different. It resolves all the issues that can now be decided and reserves jurisdiction on potential or conditional issues. So Hightower was a case that concerned a buy-sell agreement that went wrong. The arbitrator decides that one of the parties, O'Dowd, is entitled but not required to complete the purchase and issues a partial final award setting forth the party's rights and reserving jurisdiction. Reserving jurisdiction over things like what happens if O'Dowd can't get the financing or chooses not to complete the buyout? Should he be entitled to a different remedy? What happens if disputes arise during the buyout process? What about attorney's fees during the buyout process if this goes on extensively? These are all potential conditional issues, not immediate issues. So a partial final award is appropriate. Again, it does not matter what it's called. It matters what it does. Labels don't matter. So the effect of an interim award, the trial court has no jurisdiction. It needs to dismiss any petition to vacate, confirm, or correct. The Court of Appeal has jurisdiction under writ review, but only to vacate the judgment, to instruct the court that it had no power to issue the order confirming or vacating in the first place. A partial final award is different. You can go, you have to go immediately to the trial court. The trial judge will issue an interlocutory judgment because it is not a one final judgment. It is not appealable, but it is subject to writ review. So what happens to the court, the court's jurisdiction springing into or not springing into existence based on these awards? That's one half of the coin. The other half is what happens to the arbitrator's powers. So it's often said that once the arbitrator issues even the true final award, he is now functus officio, which, as my Latin teacher, who would often dress as an ancient Roman soldier, would tell you, means of no further authority. That would be nice in Latin, but within the matrix, things work a little bit differently. There are exceptions made. Why? Because we want to make sure that the arbitrator can take care of some things to fix problems so that we can avoid vacatur. Under CCP 1284, the arbitrator has the power to correct an award. That means to change in a miscalculation, some mistaken description, something about the form of the award, but it can't change the result from black to white. Parties have a 10-day period in which to apply. The arbitrator has 30 days in which to grant, and if the arbitrator doesn't grant, it's deemed denied. This is the extent of the arbitrator's statutory power, but the courts in the matrix go further and give arbitrators the power to amend or modify a decision. Now, they can't, again, change black to white. They can't redecide that which they've decided, but they can add in inadvertently omitted issues. And this is because there is a long line of cases in California that holds that if you have 25 causes of action and the arbitrator decides 24 of them, but missed one, the result is to vacate the award in its entirety, tear the entire thing up, send you back to arbitration. You can choose that you're not willing to consent to the same arbitrator, and everything needs to be done again. So we give the arbitrator the power to decide those kind of inadvertently omitted issues. Now, there's a split of authority. Some courts are stricter on this and say that the same 10-day period, 30-day period that the statute provides for correction applies here too. Other courts have been much more liberal, much more willing to indulge matrix-like tendencies to allow for modification and allow this to go all the way up until the trial court actually confirms the award. Now, this is an area that, to me, having been down this road many times, it is very clear to me. It is also an area that I see courts and arbitrators and parties confused by all of the time. The appellate nerd in me really enjoys Lomke versus Patel, a Justice Hofstede decision from 2020. It is published. It decides absolutely nothing new whatsoever. What it does is elegantly provide a walkthrough of what it means to have a final award, the consequences, and the arbitrator's remaining powers. So it clarifies and provides this wonderful teaching moment that can be used with arbitrators and judges. Now, once we know we have an award that is subject to confirmation or vacatur, we move to our next step. And under California law, the court has 4 options and 4 options only. The court can dismiss the petition, say if it is untimely, premature. The court can confirm the award and enter judgment. The court can correct the award and confirm it as corrected and then enter judgment. Or the court can vacate the award in its entirety. There is no such thing as partial vacatur. There is no limited remand back. The award is either fixed and confirmed through confirmation or through correction, or it is vacated in its entirety. Now, this has been something that courts have been disturbed by, have pleaded again and again with the legislature to change. So in 1978, M.B. Nazinovich, this is yet again one of those cases that I mentioned, where it was very clear the arbitrator missed one cause of action, and the court had absolutely no choice. It had to tear up the entirety of the award, start the entire process again, defeating the whole principle that this is supposed to be a relatively speedy and cost-effective means of dispute resolution. If this had happened on appeal, we would have sent you back to resolve this one cause of action. But because it happened in arbitration, the whole case is re-arbitrated. They begged the legislature has seen fit not to do anything. Now, while I've said that there are 4 and only 4 options in the matrix, some courts try to say that there are a 5th. When an award decides all of the issues, but perhaps does it in a way that's ambiguous, a way that the judge can't reduce to a judgment, some courts have said that we can remand so that the arbitrator can just explain what they meant. There's also some authority that has been very much criticized that if the only remaining issue has to do with attorney's fees, that isn't the merits of the case and that can go back down to the arbitrator. Again, highly questionable, looks like wrong-headed, if you would ask me, looks like something that is bound to be overruled sooner rather than later, but that option does currently exist. The process on your left is the statutory process. There is a petition to confirm or to vacate, a response, and a hearing. That's it. On your right is what litigators always do. I have seen one case where a party complained about it, that it wasn't allowed by the statute, and the judge shrugged and said, I'm going to look at everything. There's typically then a petition, a response, coupled with a cross petition that exists for only one reason, to allow the cross petitioner to file a reply that the statute never contemplated in the first place. Now, if I have suggested to you that this is a rather flexible process, please understand it's not by a long shot. In fact, there are some things in here that are rules that some might treat as traps for the unwary. These are rules that I check every single time, and then I double check every single time. So remember, the system is designed to confirm. That's what the matrix wants. And so it has procedural rules that lead to that end. Now, some fair amount of disclosure here. The California Supreme Court is taking up some of these issues in a case that is almost completely briefed now. It's going through the amicus process now. It's Law Finance Group versus Key. This is one of my cases. So what I'm going to be presenting to you is our argument in that case, but it also happens to line up with what I have counseled every litigant and every trial lawyer in every arbitration case that I have been doing for years and years and years before Law Finance Group was decided. So what we have is a sequence of statutes. 1286.4 tells us that the court cannot vacate unless a petition to vacate or correct has been duly served and filed. And its parallel statute, 1286, says that the court shall confirm unless it vacates or corrects. And together, these are a constraint on jurisdiction, a constraint on judicial power. If you don't have a duly served and filed request to vacate, whether it is through a petition or a response, the court has no power to vacate, and instead it has to confirm. So what does it mean to duly serve or file? Well, under 1288, if you're looking to confirm an award, good news, you have a long period. You have 4 years in which to seek confirmation. If you're seeking to vacate, you have just 100 days, or the court's jurisdiction to hear your request for vacatur is cut off. How this pans out really, there's a 10-day waiting period in which no one is supposed to file anything except a request for correction or modification with the arbitrator. Then you have the next 90 days in which you can seek to vacate an award, and then the balance of the remaining 4 years in which an award can only be confirmed. The kicker, however, is if I file a petition to confirm an award, you're not filing a petition to vacate. You need to file a response that seeks to vacate. And all responses, no matter what they seek, have to be filed within 10 days of the petition. So that means I can cut your 100 days down to 10 days. And what that means is you need to be thinking about arguments for vacatur, not once you get the award or once you get the other side's petition to confirm. You need to be thinking about petitions to vacate arguments before you get an award. And in fact, we love it when people come to me or someone else at my firm who think about this thing as appellate lawyers do, so that we can start working with the trial lawyers to brainstorm vacatur arguments even before we get the award, particularly if we see a hint that we know which way the arbitrators are going. It's just what allows us to get out from behind the 8 ball. Now, the 10-day rule does have exceptions. It can be extended by written agreement of the parties, and written agreement is important. It can also be extended by the trial court for good cause. But notice it is the 10-day response deadline that is subject to extension. The 100-day period is not. So what does that mean? That means if I file my petition to confirm your award on day 95, you don't have 10 days to file your response. You don't have 10 days that is subject to extension. You have 5 days because your response seeking vacatur has to still fall within the 100 days. There are similarly complex rules regarding service. And again, this is where I always look to the statute. 1290.4 lays out the rather complicated rules. It first looks to the arbitration agreement itself and says whatever service is provided there, that's what applies. But understand, it's not going to be the general notice provision of the contract. It's going to be specific to arbitration issues. If you don't have that, which is most cases in California, the petition to confirm or vacate needs to be served like a summons. It means it needs to be served on the party, not on the lawyer. And it needs to be served personally, not by mail. Of course, there are other rules if that party is outside of California. I always try to hammer this home by talking about a case called Aber versus Roars, and I appreciate that at this point I've broken the wall of the matrix. I have a younger son who's elementary school. He got very upset that his older brother understood the matrix references. So this is fairness. So the case of Abers versus Roars involved a dispute over a ground lease for condos. The arbitrator issued what everyone, including all of the judges, recognized was a, quote, devastating award. The court emphasized how inconsistent the award was with the court's own interpretation of the lease. This was a judge who, or this was an arbitrator who got it wrong. Procedurally, 2 months after the award was served, a petition to vacate was filed and served. That's still within the 100 days, but it was served on opposing counsel by mail. That is not a duly served petition. 39 days later, which if you do the math comes out to the 101st day, opposing counsel writes, I do not accept service on behalf of my client. So we don't have a duly served petition, and it's impossible to duly serve it because the 100 days have already lapsed. The court has no jurisdiction to vacate, no matter how devastating the award. There cannot be estoppel. There cannot be 473 relief. There can be nothing other than a confirmed award. So how do you stop the sad, sad tale of Abers versus Roar from becoming the sad, sad tale of you? Think about your vacatur arguments early. Double check all of the filing rules and service rules. Once you're done with that, triple check all of those rules. And lastly, assume that you're going to have service problems. I have seen cases where parties will dodge service because they can. And so these are problems that as trial lawyers, you have to deal with occasionally, but here you've got a 100-day clock. So again, you need to work very quickly, assuming that these kind of problems are going to exist. Now, when we turn to the substance, of course, it's all going to be coming down to policy and how you can possibly dodge bullets and run against walls. There is no review for factual or legal error, and we have really narrow statutory grounds. In fact, no matter how broadly, when you read the statute, something may sound, understand that these are always here as backstops against process. These are process arguments about the arbitration, not substantive issues. For instance, 1286.2A5 addresses the arbitrator's refusal to hear evidence that causes substantial prejudice. Now, this is the sort of argument that appellate lawyers make all the times. There is an evidentiary ruling excluding evidence. It was wrong. It prejudiced my client. I want a retrial. Yeah. I don't think it means what you think it means. In arbitration land, the matrix treats it much, much narrowly. it means more than an error of law regarding the rules of evidence. If the arbitrator got that wrong, that's just an error of law that's not reviewable. So what does it deal with? It deals with a structural problem, a fairness in the proceeding. Not that the arbitrator wrongly excluded a piece of evidence, but that the arbitrator allowed one side to present its evidence on an issue and excluded the other side from presenting any evidence whatsoever. That's a fairness issue. That is the kind of exclusion of evidence. That's Heimlich versus Shivji. And again, it just is an application of our bedrock principles of arbitration. There are major issues that come up, very strong arguments that can be made about failure to comply with the disclosure rules. Those can be found in the statute. They can also be found in the ethics rules for arbitrators. Similarly, if the arbitrator is subject to disqualification but doesn't disqualify himself, another powerful method. And here, all of your normal 170.1 means of disqualifying a judge, they apply. A lot of these kind of cases can be found in one of my recent decisions in Jolie versus Superior Court. It addressed a private judge issue, but again, the overlap with arbitrators is actually quite close, and the Jolie case delineates the lines between them. The trick with this line, while powerful, is you really need to be raising these issues very promptly. If there is a disclosure issue that you can tell at the get-go early in the arbitration, you need to raise it immediately. If you're aware of the grounds for disqualification, you need to raise it immediately. The court is going to treat anything else as gamesmanship and as abusing the arbitration process. Corruption, fraud, undue means, arbitral misconduct. The undue means category is a little bit strange and kind of has some body of law behind it, but as a general matter, these, if you manage to have evidence of this, my God, either you're that good of a lawyer or the arbitrator did a really bad job at showing his hand, but this is an area. The vast majority of the cases are going to come under some variant of the arbitrator exceeding the powers. And the way I like to think about this is that while the arbitrator has fantastical cosmic powers, like the genie, he also has an itty bitty living space. He cannot exceed the powers that the parties have given him. Those powers are rooted in the contract, they're rooted in the arbitration rules, are rooted in the submission to arbitration, and are in the briefs. And you should be careful in studying each of these to see how they broaden or narrow an arbitrator's otherwise existing powers. Deciding an unsubmitted issue, that's a variant of exceeding powers. Failure to decide all submitted issues, as we've talked about, that too is a powerful way, but be careful under Rodriguez versus Keller. We're going to assume that the arbitrator decided everything. You need proof positive evidence that you submitted this question to arbitration and that the arbitrator failed to deal with it. Something very, very clear. A decision on claim 1, claim 2, claim 4 that skipped claim 3, that'll do it. But an award that's much more general, Bob owes Sam $1 million, period, one sentence only, we will presume that that decided all submitted issues. Remedies can be forbidden by contract. So carefully study your agreement to see whether the arbitrator has run afoul of that rule. And in California, parties can expand review. They can't do so under the FAA, but the FAA will not preempt if the parties have done this. Cable connection is the case from the Supreme Court, the Cal Supreme Court, that gives us the magic language. I have seen lawyers try to draft variants of this. Do not do it. Use both prongs of this. It needs to say that the arbitrator has no power to commit errors of law or legal reasoning, and that the award can be vacated for it, a restriction on the arbitrator's power, a grant of power to the judges. Don't vary it, use it, live it. The other question I often get here is the de novo pub an actual place? Yes, it is. Have I ever been there? No. You can take me there, but it requires a plane flight. The other big exception here that I wanted to address is the public policy exception. Now, we've talked about public policy as a means to avoid arbitration entirely, that to resist a motion to compel arbitration, you can say that the entire contract is void for violation of public policy. That is an issue under California law for the trial judge to decide. And that is the full normal kind of public policy analysis that you're used to in evaluating a contract. We can look to all sources of law to determine what that public policy is. So we can look to statutes, we can look to regulations, we can, in Shepard-Mullen, look to the rules of professional ethics, we can look to cases. On the back end, when we are arguing that the award conflicts with public policy, while this does allow for review for legal error, is a much more constrained sort of analysis. It has to be a dominant, explicit, well-defined legislative expression of public policy. That it's in the rules of professional ethics doesn't matter. That it's in some regulation doesn't matter. It needs to be in a very clear statute that we have a public policy. And why? Because we have a strong public policy from our legislature in favor of arbitral finality against review for legal error. And in order to combat that, we need an equally strong legislative expression of public policy on substantive issue. The conflict between these two is what allows the court to engage in the much more thorough analysis as to whether this arbitrator has committed an error of law or fact. In fact, there are cases that hold that what the trial court needs to do is essentially hold its own mini trial, take evidence, live evidence, if that's what the court wants to do, to decide the factual issues and then understand the legal issues, apply facts to law and decide, is there a public policy violation here or not? Now, I'm an appellate lawyer, so I have to leave you with some guidance regarding appealability. So as we've said before, the matrix wants to keep you in arbitration as long as it can, and the appealability statute reflects that. So an order compelling you to arbitration is not appealable. You can take a writ from it. It is typically a rather hard writ to get, granted. Otherwise, the order compelling arbitration is something that you will appeal from the judgment that ultimately will be entered after the full arbitration and after the award is confirmed. An order denying arbitration, one that sends you on the path of litigation, that is immediately appealable and needs to be immediately appealed. On the backside, after confirmation, you cannot appeal from an order confirming. What you need to get is a judgment confirming, and the judgment, of course, is appealable. If you have a correction, of course, there's also going to be confirmation of the corrected award coupled with a judgment confirming the award, again, appealable. When it comes to vacating an award, it gets a little stranger. An order that vacates an award is immediately appealable, unless that order specifies that the parties will go back to arbitration for a rehearing. Now, it does not matter what will happen, it only matters what the order says. So if we all know that the vacatur is going to result in relitigation, a new trial, but the judge doesn't say so in the order itself, you have an appealable vacatur order. The parties can choose. Maybe they want to litigate. Maybe they want to settle. It's theirs to choose, but they have an appealable order. If the judge sends you down explicitly to arbitration, then and only then Are you much more like an order compelling you to arbitration? You can seek writ review, but you cannot appeal it. And again, an order dismissing a petition is one that is immediately appealable. That is bringing us to the end. I will leave you with a little bit about myself. Why hire appellate counsel? We are excellent at providing tips at seeing things in a different way, providing a fresh perspective, looking at things as a reviewing court will, whether that's an appeal, a writ, or trial court proceedings on something like VACATUR. We have a deep understanding of the appellate process, a very different kind of written and oral advocacy than trial lawyers do. I cannot do what trial lawyers do. I don't know how you do what you do, but we do things a little bit differently, as do appellate justices. We look at things without being so focused on one particular case and the law applicable here, but how that area of law intertwines with other areas, how this precedent can affect something else that will happen. Appellate courts have recognized that recycling trial level points and authorities without reconsideration is a substandard process. So with that, I can turn to any questions that you might have. I thank you for your time. So I'm looking quickly at your questions. Tips for compelling arbitrations of non-signatory defendants who conspired with a signatory defendant to cause the signatory defendant's breach of contract containing an arbitration clause. Well, that's highly specific. I can tell you that it is often overlooked. There are rules that non-signatories can be bound by an arbitration award, can be, bound by an arbitration agreement. They can use it to compel you to arbitration. You can use it to compel them to arbitration. I don't want to offer specific advice regarding something that is that clear a fact pattern, but certainly look into areas about non-signatories. I'm not seeing any other questions. Oh. Well, one more. Will an arbitration provision providing for waiver of injunctive relief by only one party be upheld? Waivers of injunctive relief get complicated. It depends whether we're talking about public injunctive relief or private injunctive relief. There are some statutes that afford the possibility of public injunctive relief, things like UCL claims, where you are seeking an injunction that benefits the entire population of California. There's going to be public policy issues where there's a waiver of that. Whether there is a waiver otherwise, whether that's a problem otherwise, I'm not certain, and it feels like under your hypothetical, it's going to turn largely on unconscionability issues, whether this is adhesive, those sorts of things. Another question: in confirming an award, when does the FAA or CA apply? 1 year versus 4 years. You're going to be very, very careful on this. I don't want to go about breaking down. Be mindful, both of them have rather strict time limits. There is somewhat more flexibility on the FAA to address issues beyond the shortened period, but it's something you do want to be careful about. That is going to do it for me. If anyone has any other questions, I'm happy to address them. If you want to give me a call or send me an email. But otherwise, thank you very much for joining us, and have a great rest of your day.